Hello, you're on to Law Mistral. I am Nwisi Mudukbe Mnyim. On this episode today, we'll be looking at intellectual property for inventors and innovators, a practical guide to protecting creativity and commercializing ideas. But before I go into the full menu that we have for you on this topic, let me kindly pause and enjoin you to be a member of our community if you are not already one by simply clicking on the subscribe button, and you immediately be subscribed, becoming a member of this growing community of legal enthusiasts. And I also enjoin you to click on the like button, click on the share button, and do not walk away quietly. Kindly drop a comment in the comment section. I will meet you in the comment section. So, like I said, today we are looking at intellectual property for inventors and innovators, a practical guide to protecting your creativity and commercializing your ideas. I will take us through a quick outline for our discuss, and through this episode we'll have an introduction, then we'll take a look at the meaning of intellectual property. After that, we'll be looking at the forms of intellectual property that are relevant to innovators as well as inventors, and to wit, we'll be looking at patents, we'll be looking at industrial designs, we'll look at copyright, we'll look at trademarks, we'll look at trade secrets. Then we'll move away from there to look at why intellectual property matters to you as an inventor or as an innovator. Then we'll press on to examine how you can commercialize intellectual property. Afterwards, we'll look at intellectual property strategy for startups. Then we'll examine the challenges that are facing innovators, particularly in Nigeria. Then we'll wrap up this episode by way of a conclusion. So basically, that is the run through of what you'll be having on this episode today. So let me begin with the introduction, by the way. Now, innovation has become the currency of the 21st century today. The currency of the 21st century today is not akin to, say, a traditional currency in terms of dollars, euros, pounds, naira, and what have you. The currency of the 21st century today is innovation. Yeah. So across the globe, we find that economic growth is increasingly driven by knowledge, creativity, as well as technological advancement through persons rather than natural resources alone. And of course, this has made the truism true, if I may put it that way, that ideas rule the world. What rules the world are ideas of persons, ideas of nations. And that's what has marked the world into the various strata, developmental strata or power strata that we have in the world today. Whether a nation is classified as a developed nation or is classified as an underdeveloped nation is innovation driven. It's innovation that marks nations out, that marks nation to nation, is simply innovation. So every day you see inventors and innovators develop products, software applications, medical devices, artistic works, engineering solutions, and business models that have the potential to transform industries and indeed improve lives. However, an innovative idea, no matter how brilliant it is, has very little commercial value, unfortunately, if it is not adequately protected from imitation or unauthorized exploitation. Now, in Nigeria, for instance, one very good industry that you understand this clearly from is the entertainment industry. Whether it's music, whether it's the film industry that is popularly called Nollywood, their biggest problem is imitation and unauthorized exploitation has ravaged that industry, making persons not to benefit as much from their creative work as they should have. And this is a situation that is colloquially described as monkey dey walk, baboon dey chop. So you have to find a way of protecting your innovation, and that is where IP or intellectual property becomes very relevant. Intellectual property or IP exists, in the law thereof exists in order to provide legal protection for the product of human intellect while encouraging further innovation for societal benefit. Now, Nigeria has witnessed remarkable growth in innovation, and so have other jurisdictions as well, particularly in agriculture, fintech, health technology, renewable energy, and creative industries. Startups founded by young Nigerians continue to attract global investments. Yet, you see, many of these innovators remain unaware of the legal mechanisms that are available to safeguard their creations. Now, many inventors, particularly, many innovators, they disclose their inventions prematurely. They make them public before seeking legal protection, which is wrong. Sometimes when you do that, it makes you lose the ground for protection, So and then others fail to register their trademarks or document ownership of their innovations. Such omissions, they will usually result in unavoidable disputes and financial losses that you could have prevented, that you didn't even need to go through in the first instance. So you see, this episode examines the concept of intellectual property, the principal forms of intellectual property protection that are available to you as an inventor or an innovator, the importance of protecting your innovation, the strategy for commercializing your intellectual property, and finally, the challenges that you may face as an innovator in Nigeria. And this may be similar challenges also in other jurisdictions. But in any case, let us look at what intellectual property means. What's the meaning of intellectual property? When we say intellectual property, what do we really mean by intellectual property? Let me say that intellectual property is ipso facto a property. So intellectual property is first of all a property. It is only an intangible property, a type of property that is intellectual. That's what intellectual property means. It's a property that is albeit intellectual. The World Intellectual Property Organization, that's WIPO, defines intellectual property as a creation of the mind, including inventions, literary devices, and artistic works, designs, symbols, names, and images used in commerce. So unlike tangible property, like say machinery, land that you are very, very familiar with already, intellectual property actually consists of intangible assets created through human creativity, human ingenuity, human genius, human thinking ability or capability or capacity, if you like to put it that way. So the legal rationale for intellectual property protection lies in balancing private and public interest. What do we mean by private and public interest? Let's say that the private interests are the interests of the innovator. So as an innovator or an inventor, you have your private interest. What are your likely interests? Your interest may probably be that there's a problem in society. Oh, you have a burden to bring a solution to this problem. So you go in to think, to brainstorm, to put in your resources, material and non-material resources, your time, your money, your energy, your industry, your everything, and you came up with a solution. Now, you want to gain. Your other interest may also be that your name should be out there, that you are the one that brought about this solution to this particular problem. And finally, you will want to be rewarded by way of any funds, of course, any resources, gaining money from this labor that you have done. These are your private interests. And what are the interests of the public? The interest of the public is that they want this problem solved and they want to get access to the problem at minimal cost. Those are the public interest. It is intellectual property that reconciles these otherwise conflicting interests, and it becomes a win-win situation for you as a private innovator and for the public who are yearning for that solution. So by granting inventors exclusive rights for a limited period, society rewards creativity while encouraging the disclosure of knowledge that eventually enters the public domain to also enrich the knowledge within the public domain. So intellectual property therefore promotes innovation. It attracts investment. How does it promote innovation? Because you are now protected, you are encouraged to keep innovating. And then this innovation, because this innovation can bring in resources, then investors are attracted. That's the way that intellectual property attracts investment. And then when there is an investment in an area, it stimulates economic growth. So intellectual property also stimulates economic growth. And finally, it encourages technological transfer because the protections are not ad infinitum. They are not, the years of protection are not to eternity. There's a point that gets to that the protection lapses and the knowledge now falls to the public domain, so everybody in that sector can have that knowledge to enrich the knowledge or state of the art in that particular sector. So for investors, intellectual property is often more valuable than physical assets. The world's leading technological companies derive a significant proportion of their market value not from buildings, not from infrastructure, not from equipment, but they derive it from their intellectual property, like their patents, their trademarks, their copyright, their trade secrets, and what have you. Now, you can take away their infrastructure, take away their equipment, take away all of those, but if they retain their intellectual property, those intellectual property that they retain will bring back everything that you have taken away from them. So, let's look now at the forms of intellectual property that are relevant to you as an inventor or as an innovator. And the first of them that we're looking at is the patent. So a patent is the protection that is granted for an invention. It grants an inventor the exclusive legal right to prevent others from making, using, selling, or importing an invention without authorization for a specified period, usually 20 years. And you see this in section 7.1, in section 7 sub 1 of the PDA. The PDA is the Patents and Designs Act 2004. Let me pause and quickly say something that will help you get the rationale behind different types of protection. Actually, intellectual property, all of these forms of intellectual property do apply to different types of intellectual property. What do I mean by this? We have patents, trademarks, trade secrets, all of these. They are for different types of protection. Now, intellectual property does not protect your idea. What it protects are the expression of that idea. Why is it that intellectual property doesn't protect ideas? Intellectual property does not protect ideas because ideas that are in your mind are and have not yet been expressed are very safe. They are in the safest point they can be. And this is why there is an English adage that says that even the devil does not know the construction of a man's heart. Meaning that your ideas, even the devil does not know. And when they say that even the devil does not know, it means that other persons don't know. And what they do not know, or what they do not see, or what they do not have access to, they cannot steal. So those are safe. The law doesn't need to protect what is already safe. Is that all right? Because that would be superfluous. Okay. So, but once your idea now finds a form of expression or a medium of expression, then it can now be stolen. So if your idea, for instance, finds an expression in a song, it's in a song form, it can be stolen. Okay. So you remember that there was one time there was a tussle between members of plantation boys that African Queen was not an original song to Two-Face Idibia. So, but you see, whoever it was that had composed "You Are My African Queen," "You Are My African Queen," whoever it was that composed the song, if the song was still in his head, Two-Face would not have had access to the song. But immediately the song found expression, somebody had access to it. So it's when the song, the idea you have in mind finds an expression in a tangible medium, that it now needs protection. So the kind of medium that your idea expresses itself in will determine the type of protection that your idea needs. So if your idea expresses itself in the medium of invention, then what your idea will be needing as way of protection will be a patent protection. If your idea finds itself expressed maybe in a written form, what you'll be needing to protect it will be copyright. If your idea finds itself expressed in terms of a mark that distinguishes a trade, what you'll be needing will be a trademark. If your idea finds itself expressed in a medium of design, and that design is used in industrial purposes, what you'll be needing for protection will be industrial design. So that's why I felt that we needed to quickly take that, so that you understand the justification for the different types of protection that are available. So now I'm coming back to the protection that we were looking at, which is patents. Is that all right? So we're looking at patents, and I had said that patents would avail you if your idea is expressed by way of an invention. So a patent is that protection that you get for an invention. It grants an invention, like I said before, a period of protection for 20 years. And you see this under section 7 sub 1 of the PDA, which I told you earlier is the Patent and Designs Act. Now, what does a protection do? It normally excludes others from exploiting that your intellectual property for economic gain. Okay, so under the Nigerian PDA, an invention is patentable if it passes these 3 requirements. The first requirement is that it should be new. When they say that your invention should be new, it may not be entirely new, but it may be an improvement upon what has been there before. So that portion of improvement, if it is new, it will pass for the test of newness or novelty or originality. So for instance, There was a certain time that we had TVs, isn't it? Black and white TVs. Then at a certain developmental epoch, somebody came about with the colored TV. If he's going to get a patent for his invention, he will not get a patent for television. He will get a patent for the colored component of television. And I hope that that is well understood. That would be the part that is new. Then a second test that you must pass is that it should result from an inventive activity. And the third test is that it should be capable of industrial application. So all these three things, they must be there. They must be there together. It's not that if any one of them is not available, then you are not going to get the patent. All three must be present. So, and you will see this. You kindly check sections 1 to 3 of the PDA.
Yes.
See also the authority of KSR International Company versus Teleflex Incorporated. You will see the citation supplied on your screen. So examples of things that you can patent include medical devices, agricultural machines, pharmaceutical products, mechanical equipment, artificial intelligence applications, manufacturing processes, and so on. So a patent does not merely protect an idea, like I said, it protects the practical application of that idea. So for these reasons, innovators should maintain confidentiality before filing a patent application, because premature public disclosure may destroy the novelty requirement, the newness of it. So once granted, the patent, like I said before, will last you for 20 years. I'll now go to industrial design. Now, industrial design protection avails any product, the aesthetic component of products or ornamental appearance of products rather than their functional purposes. Now, example of things that you would want to get an industrial design protection for would include product packaging, furniture designs, automobile body shapes, fashion accessories, electronic devices, and so on. Now, a design protection is especially valuable for innovators whose competitive advantage lies in their product appearance. Now, once granted, this protection will last for 5 years. You see section 20 sub 1A of the PDA. Let us now look at copyright. Now, copyright protects original literary, artistic, musical, scientific works once they are expressed in tangible form. So registration may generally seem unnecessary, and please take note of my use of language. It may generally seem unnecessary. Now, why is it that it normally seems unnecessary at times to people? Is because once expressed, copyright becomes automatic. So you don't need to register it before it is protected. It is automatically protected. So for that reason, people may feel that there is no need registering your copyright. But copyright registration will become very useful to you when you now go into a case of litigation and you are needing evidence to prove that you are the first person that brought about that work. Then at that time, registration would avail you as a strong evidence. So registration serves a strong evidential advantage or evidential value. So it's advisable to register nonetheless. Thank you. Now, those things that as an innovator you need to be copyrighted include things like software, computer source code, technical manuals, training materials, architectural drawings, engineering diagrams, databases, digital content. All of these things, they need to be copyrighted. You need to protect them. The protection you require is copyright. So copyright does not protect ideas in themselves also, but the expression of those ideas. Upon grant, a copyright will last you normally for 70 years as an individual. You see the authority of Section 19, Sub 1A of the CRA 2022. So the CRA is the Copyright Act. I will now go to trademarks. Now, a trademark, I like to define a trademark in a very loose and colloquial manner so that you always remember what a trademark means. A trademark is actually the mark of a trade. A trademark is the mark of a trade. What do I mean by a trademark is the mark of a trade? A trademark is a mark that marks out your trade distinct from every other trade. So when you see this sign, like a mark this way, like you are ticking something this way on a product, you know that, oh, this is Nike. And there is a mark that you will see that you say, oh, this is Louis Vuitton. There's a mark you say, this is a Gucci product. There's a mark you see, you say, this is an Apple product. There's a mark you see, you say, this is HP. So every trade that is worth its metal has a mark. Sometimes those marks serve as their logos, and they mark out their trade. So even if they don't write their full name and they just put that mark on it, you know that, oh, this is belonging to and it normally those marks normally draws customer loyalty. So it's actually an asset also, and it needs protection. So a trademark is any sign that is capable of distinguishing goods or services of one enterprise from those of another. So examples include brand names, logos, product labels, company names, slogans, and even sounds. Okay, so strong branding increases consumer confidence and business value. Many investors place significant emphasis on whether a startup has secured a trademark protection before even committing their funds to such a startup. So we will now look at trade secret. What is a trade secret? In a loose way, in a loose manner, or a loose sense, let me say that a trade secret is the secret of the trade. Now you get it. So that's it. It's the secret of that trade. The secret that trade has that keeps it afloat, that keeps it ahead in that sector. That is what a trade secret means. So innovators are better, innovations, they are better protected through confidentiality negotiation, or rather than going to go and register, and I want to register a secret. When so many people know a secret, it is actually no longer a secret. So trade secrets include confidential business information that provides commercial advantage because it is not publicly known. Let me give you a folk tale from the thief people of Benue State here in Nigeria, and that folk tale typifies why secrets can serve as your protection. Now, this tale has it that once upon a time, the fox never used to eat cockerels. Rather, the fox used to be a friend to the cockerel. And why was it so? It was so because the fox feared that the comb atop the cock's head was fire. So it feared that if it wanted to eat the cock, the fire on the cock's head would consume it. And that fear made the fox never to eat cocks. One day, Mr. Cock became so confident in this his friendship with the fox that he now told the fox that, do you know that this comb on my head is not fire? It's no fire at all. Bring your hand. Then he took the fox's hand, put it on his head, and the fox suddenly discovered that it was no fire at all, it was flesh. And that was the end of the fear of the fox had over the cock, and started eating the cock from that day until now, and even until world without end. I like to believe that the foxes will continue to eat the cock. But what made his fear of the cockroach to end was the release of the secret that the cock had. So even as an innovator or as a business person, if you carelessly behave like the cockroach and release to your competitors who are foxes in your sector your trade secret, you will become consumed by those foxes in your sectors. That's why trade secrets should be kept as secret. I will now share a funny tale I had with you while I was taking this class in a physical class somewhere in Benue State. And then one of the students asked me that, why is it that security agents, now the specific security agents he referred to was the EFCC, who are in charge of combating economic and financial crimes in Nigeria. So he said, why is it that EFCC officials go after Yahoo boys who are cyber criminals and then force them to tell them their trade secret when trade secrets are protected? So I looked at the boy and told him, boy, and I told him, boy, I'm teaching you trade secrets. I'm not teaching you secret trade. Do you understand the difference? And that was how I was able to wriggle myself out of the use of semantics in class. So how you arrange these things will completely change the meaning thereof. A trade secret is the secret of a trade. A secret trade is a trade that is secret. Take note of that. So now, examples of things that you should protect by virtue of trade secret are your manufacturing formulas, your algorithms, your customer databases, your marketing strategies, your recipes, your source codes. All of these should be treated as trade secrets. So unlike patent, trade secrets may potentially last indefinitely provided confidentiality is maintained. And one company that is celebrated for how effectively she has kept her trade secret is Coca-Cola, and she's of course benefiting from it. That's why it's difficult to counterfeit Coca-Cola products, because the formula is well protected by trade secrets. So now we'll now look at why intellectual property matters to you as an innovator. Intellectual property transforms ideas into valuable commercial assets. First of all, intellectual property or IP grants exclusive rights that enables an innovator to prevent unauthorized copying. Without legal protection, competitors can reproduce innovations without incurring research and developmental costs that you as the innovator incurred while coming up with that innovation. Secondly, intellectual property attracts investors. Venture capitalists, angel investors, and financial institutions frequently conduct IP due diligence before investing in technology companies or technology startups. Okay. And the IP thirdly protects licensing, facilitates licensing. Instead of manufacturing products personally, investors may license others to use their inventions in exchange for royalties or in exchange for a fee, if you would like to put it that way. Then fourthly, IP enhances business valuation. Many multinational corporations derive substantial portions of their market capitalization from intangible rather than tangible assets. Then finally, IP promotes economic development by encouraging research, technology transfer, as well as foreign direct investment. So let's take a look at how you can commercialize your intellectual property. Is that all right? So protecting an invention is only the first step. Innovators must also understand how to commercialize their intellectual property, because if you protect it, nobody is touching it. That helps you in that nobody is touching it, but it doesn't bring food on your table, doesn't increase your bank account. You have to know how, when you are inventing something, you have to know how to put it to work, that it in turn produces money for you, and that's the crux of commercialization. So basically, commercialization may occur through manufacturing and selling products directly. By that is meant that this, your innovation, you are manufacturing it yourself, you are also selling it directly to the end consumers. You may also license your IP to third parties. So they would then pay you a fee for that license. And when that IP product is licensed to them, it will define the period of time they are supposed to exploit it, and they will also be liable to pay you certain fee, agreeable fee, that you have agreed under the license arrangement. You can also franchise it to others, grant a franchise to others, using the franchising business model. That way also you can commercialize your IP product. Another way that you can commercialize your IP product is by creating technology spin-off companies. You can also sell patents or trademarks outrightly, the same way you sell off a tangible property like, say, land, machines, houses, things like that. You can sell off your IP, your patent or your trademarks outrightly to others. And finally, by forming strategic partnerships with investors, you can also commercialize your IP product. Now, we'll now go to the intellectual property strategy that you require for a startup. So innovators have to adopt a proactive intellectual property strategy from the earliest stages of their product development. The earlier you are able to come up with a strategy, an IP strategy for your IP product, the better for you. So such strategy could include: one, every stage you went through in coming up with that innovation, you need to document it. Then you have to also conduct a prior art search before investing heavily in product development. So once you have developed something, please do a search to know whether this thing that you have developed is viable, whether it's actually yours. There is not a similar thing in the market before you heavily invest in it. Then file for patent. Apply for your patent before you disclose to anyone. Before disclosing your innovation to anyone by any method at all, even sharing it with others, or the trap of publication is always there for academics, because something is telling you that, oh, if I don't publish, I'm going to perish. So you have an innovation, you want to quickly publish in a leading journal so that you will have that publication for your promotion. Yes, you may get it, but When it now gets to patenting, you may not be able to patent because once published, it has already been disclosed. So it will lose its newness, it will lose its novelty component. So you have to make sure that you apply for your patent before you go disclosing your innovation. You should also register your trademarks early. Otherwise, if somebody registers that mark earlier than yours, that person is the rightful owner of that. Using confidentiality agreement with all your employees and all your business partners, you can get a legal practitioner to help out with that. Then maintaining proper records of ownership all the way, and regularly monitor the market for infringement, because that duty is upon you. And if you don't monitor the market and people are infringing, they will be making money off you. Whereas if you are able to catch them, you will get something out of them, especially by way of damages. Then finally, obtaining professional legal advice where necessary. Anywhere that you need legal advice, please do consult a legal practitioner for that. So an effective IP strategy enhances investor confidence and minimizes future disputes for you and for your establishment. Now, I will now look at challenges, and after these challenges, we will now wrap up this episode. So, despite the fact that there is increasing innovation, there are several challenges that innovators are facing as far as IP protection is concerned here in Nigeria. One of such challenges is inadequate awareness. Not many innovators are aware of the protections that they have in IP, or how they can harness this protection and be protected. Then the second thing is registration procedures. This may appear slow and costly for small businesses, but it's better that no matter how costly it is for you, it's better that you should be protected rather than unprotected. Now, what readily comes to my mind is the saying that if education is costly, try ignorance. So if protection is costly, you deem it to be costly, then you just try not being protected, and then you know that it's better you are protected than not protected. Then the third thing is enforcement. Enforcement remains difficult because litigation itself can be expensive and time consuming, and even the alternative to litigation, which is AD, alternative dispute resolution, that also is expensive and could pose a challenge to startups. So another challenge involves digital piracy, software infringement, and counterfeiting, which oftentimes undermine innovation. Additionally, research and university institutions sometimes lack effective intellectual IP policies governing ownership of research outputs from such institutions. So institutions are advised to have an IP policy where they do not have one. Now, addressing these challenges requires stronger institutional support, increased public awareness, improved administrative efficiency, and more accessible legal services. Well, by way of summary, innovation flourishes where creativity is protected. Where creativity is not protected, innovation cannot flourish, because innovators will not be encouraged to work, to research, and bring out this innovation. So intellectual property law provides innovators and inventors with the legal framework that is necessary to transform their ideas into viable and valuable economic assets. So patents, trademarks, copyrights, industrial designs and trademarks, as well as trade secrets, each performs a distinct but complementary function in safeguarding one's innovation. So for Nigerian innovators, understanding IP is no longer optional. It is now essential. You have to understand whether you are developing software, whether you are manufacturing equipment, you are creating digital content, or you are establishing technology startups. Innovation should regard IP as an integral component of their business strategy rather than a mere legal formality. So ultimately, successful innovation depends not only on generating brilliant ideas, but also on protecting, managing, as well as commercializing these ideas in a way that they bring you financial returns or gain. As the knowledge economy continues to expand, those who understand how to leverage IP will be better positioned to compete both nationally and internationally as well. So with this, we've come to the end of this episode, which is intellectual property for innovators and inventors, a practical guide to protecting creativity and commercializing ideas. You want to have this in a note form, kindly visit our website. You will find it on your screen, www.lawminstrel.com, and it has enriched you in one way or the other. Kindly click on the like button, share with your sphere of influence, drop a comment in the comment section for me. I will respond to you. And you are not a member of our community, please do join our community by kindly clicking on the subscribe button, and you will immediately be subscribed, becoming a member of this growing community of legal enthusiasts. Till next episode, I am yours sincerely, Mwesi Modupe. Thank you.